Namaste, I am Pragati and this video is about genesis and development of patent and kind of inventions protected by a patent. Patent is one of the intellectual properties. So let us first understand what is intellectual property. Intellectual property refers to a creation of the mind such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. Intellectual property includes patents, copyrights, trademarks, geographic indications, etc., which enable people to earn recognition or financial benefits from what the inventor created by striking the right balance between the interest of the innovators and the wider public interest. Now let us understand what is patent. A patent is a set of exclusive rights granted by a state to an inventor or their assignee for a limited period of time, excluding others from making, using, selling, importing the patented product or process producing that product for these purposes. Let's see the objective of a patent. To encourage inventions by promoting their production and utilization so as to contribute to the development of industries, which in turn contributes to the promotion of technological innovation and to the transfer and dissemination of technology. Now, let us see the history of the Patent Act. The first patenting related act in India was passed in 1911 by the name of Patents and Designs Act 1911. After independence, the Patent Bill was unsuccessfully introduced before the Parliament in 1949 and 1965. And finally the bill was passed in the year 1970 and the act came into force on 20th April 1970. The patent system in India is governed by the Patent of 1970 and Patent Rules 2003. This act has been amended several times in the year 1974, 1985, 1999, 2002 and in 2005, and also the rules have been amended in 2006. An important aspect of Patents Amendment Act 2002 are hastening the process of patent grant. A patent is granted within approximately 2 years of filing an application. The inventor had to fill a declaration of inventorship. The major features of the Patents Amendment Act 2005 are emphasis on indigenous manufacturers, both pre-grant and post-grant opposition avenues. In order to prevent evergreening of patents for pharmaceutical substances, provisions listing out exceptions to patentability have been suitably amended so as to remove all ambiguity as to the scope of patentability. Product patent has been included in all fields of technology, that is, drugs, food, and chemicals. The purpose of the patent is to enjoy the exclusive rights over the invention. The patent is to ensure commercial returns to the inventor for the time and money spent in generating a new product. Now let's see what can be patented. In order to be patentable, an invention must pass 4 tests, which are: the invention must fall into one of the 5 statutory classes, that are processes, machines, manufacturer's composition of matter, and new use of any of the above. The invention must be useful. The invention must be novel. The matter disclosed in the specification is not published in India or elsewhere before the date of filing of the patent application in India. The invention must be non-obvious to a person skilled in the art in the light of the prior publication or knowledge. What is not patentable? Inventions that are frivolous and contrary to natural laws. Inventions which go against public morality. Inventions that are mere discovery of something that already exists in nature. Let's see the kind of inventions protected by a patent. Utility patent. Utility patent consists of the creation of improved product or an entirely new process. Plant patent. Plant patent can be natural, bred or non-reproductive cells of the plant. In order to be granted a plant The patent must be asexually reproducible and it must be performed through methods such as division, root cutting and budding to have plant stability. A design patent. The third kind of patent applies to the unique looks of manufactured item. In case of plant patents too. The plant has unique shape, then the investor can get a design patent too. India has always acknowledged the importance of a strong patent system for the development of industry and commerce, which is evident for the amendment done to bring India at par with modern world. With the promulgation of the product patent regime in India, most of the countries are now looking for business opportunities. There has been a considerable rise in the patent filing. Innovators and inventors from all fields of technology are keen on protecting their intellectual property. Thank you for watching the video.